you all here, and thank you all very much for coming. The topic of tonight's panel is Say It Ain't Soy. Very clever pun, and I have to thank Chris, who's in the audience, for planning and for coming up with this really great title. So we're going to be discussing today labeling of plant-based alternative foods. And we have as speakers Lori Barrett-Peterson, Nigel Barrella, and Lorraine Lewandrowski. And I'm going to start just by introducing them and just saying a few words, and then we'll just get right to the presentations. Lori Barrett-Peterson, she's the chair of the New York City Bar Animal Law Committee, and she, along with Chris, helped to plan this really terrific panel and presentation that we're going to have for you today. And she does a lot of amazing work, and I encourage you all, if you are not familiar with the Animal Law Committee, just to go on our website and see some of the other great work that Lori and the committee has put on. She's a past member of the New York City Election Law Committee and a recipient of the New York City Public Service Award. Currently, she's a transactional attorney for New York City Law Department and previously worked for the New York City Department of Consumer Affairs, where she prosecuted businesses for violating global consumer protection laws and advised the public on the interpretation of such laws. To my right, I have Nigel Barrella. He's an attorney in Washington, D.C. He braved the snow to travel here today, and we thank him for that. In his private practice, he frequently works with small businesses and nonprofits and food regulatory issues. Last year, on behalf of the Good Food Institute, he filed a citizen petition with the FDA about the labeling of plant-based foods and other alternative foods. And earlier this month, also for the Good Food Institute, he filed a friend of the court brief in a California federal class action lawsuit in which he defended the right of almond milk producers to call their products almond milk. Hopefully we'll hear something about that today. And to my left, I have Lorraine Lewandrowski. Lorraine is a dairy farmer who is an honors graduate of Albany Law and Tufts University's Fletcher School of Law and Diplomacy, where she also completed Harvard Business School's Global Agribusiness program. Her clients have included the endangered Karner blue butterfly, environmental plaintiffs, local municipalities, the Amish community, and family farmers. Lorraine has served on the New York State Solid Waste Management Advisory Board as a commissioner of the Mohawk Valley Heritage Corridor Commission, and she was elected to serve as board president to lead a regional nursing home out of bankruptcy. The highlights of her law career include a law review article on contaminated property evaluations cited by the Court of Appeals while she was in law school, a decision of the day case in the New York Law Journal, and appellate practice on several cases in the 3rd and 4th departments in the New York State Court of Appeals. And she traveled here today from her farm in upstate New York, and so we also thank her for braving the snow. Before we get started, I just wanted to say a few words. At the City Bar, we always like to have a discussion that fairly represents all sides of issues and topics whenever possible. So I just want to remind everybody here today, we will be taking questions, and we ask that you reserve your questions until the end of everybody's presentation. But please remember that this is a polite and respectful forum where we can hear from different sides of the aisle. And it's okay to ask challenging questions as long as they are on topic, but please speak politely and give everybody the consideration and respect that they're due. So without further ado, I'd like to ask Lori to start her presentation. And thank you all again.
Thanks everybody for coming.
Trying to bring this more slack here.
You know what, I'll sit down. I have to read a disclaimer first. The views and opinions that I express today are my own and should not be attributed to the New York City Bar or my employer. In order to understand the current debate about the labeling of plant-based alternative foods using the words milk and cheese and similar terms in product names, it's important to understand the meaning and the history of the term standard of identity. That's a term used in the Federal Food, Drug, and Cosmetic Act. A standard of identity is a rule that sets out what ingredients a food product must contain, which ingredients it may contain, and any requirements for manufacturing. And there are a few hundred standards of identity in the regulations. And here's an example of one for maple syrup. You can see at the beginning it says that it's the liquid food derived by concentration and heat treatment of the sap of the maple tree, or by solution in water of maple sugar made from such sap. And then it says that it has to contain at least 66% by weight of soluble solids derived solely from sap. And then it goes on to say that you can add water to it, and you can also add salt, chemical preservatives, and defoaming agents. So the definition of a standard of identity is pretty straightforward, but to understand the debate, I want to give you some history about where this term came from. And to do that, I'll take you back to March 22nd, 1857, and just to give you some context, the construction of Central Park was just beginning that year. The first Otis elevator in the world was installed at the corner of Broadway and Broome in New York City. And the New York City population was surging. From 1840 to 1850, it went from 313,000 to 516,000. And then in 1860, it leapt to 814,000. And as you can imagine, as the population was expanding, Manhattan was losing its farmland. So we relied more and more on food coming from outside of the city to feed the population. 1857 is also significant because that's when Borden started manufacturing condensed milk. Up until the mid-1800s, most Americans were getting their milk products from butter, cheese, and something called clabbered milk, which is sort of like a yogurt-like substance that's sour. And that's partly because the milk bottle hadn't been invented yet, so we were eating preserved products, and refrigeration wasn't in wide use. And Americans' consumption in the 1800s was about a third of a pint per day, and that included milk used in cooking, coffee, and tea. In colonial times, breastfeeding was done for about a year. But then, in about 1840, cow's milk started to become something that was given to infants in place of breast milk more and more. The reasons for this are very complicated and nobody quite understands for sure. But if you're interested in a really interesting book about the history of milk, Melanie Dupuy wrote Nature's Perfect Drink, How Milk Became America's Drink. 1857 is also significant because in New York City, it was the year that the New York Times dubbed the Great Swill Milk War. Now, what is swill milk? The column distillery was invented in the early 1800s, and that made brewing liquors like whiskey easier. And as the byproduct of brewing whiskey, there was this mash that was made from grains like barley. And some enterprising farmers decided to hook up their stables, their cow stables, to distilleries and to feed the cows this hot leftover mash that they called swill right when they were done using it for the purpose of making liquor. And it was almost all that they were feeding to the cows at that time. So the cows were very sick, and they became lame. There's a picture of one of these stables, a distillery and cow stable at 39th and 10th. The cows were very lame. They sometimes lost their teeth, they lost their tails, they had a hard time standing up. And the conditions in the stables were quite bad. This is a picture from the from Frank Leslie's Illustrated News of Henry Berg from the ASPCA inspecting the swill cow stables. And I'm going to ask Barry to read a letter to the editor that he wrote in the 1850s describing the stables.
Henry Berg's statement. At Williamsburg, my attendants and myself found in one large stable, according to the admission of the man in charge, 800 cows and oxen, each secured by a short rope about 18 inches long, and many confined in stables 30 inches wide, while others stood two together in twice that space, thereby rendering it more difficult and dangerous to the animal to lie down than to stand perpetually, month after month. Upon opening the doors of these foul prison houses, midnight darkness and a hot and pestilential vapor arrested our progress for a time. But after causing the window to be opened, we entered, and a spectacle presented itself of filth and wretchedness that beggars all attempts at description. Within were to be seen these uncomplaining, unoffended victims to man's cupidity and cruelty, many of them in a cramped attitude, wallowing in the most disgusting filth. Some tied by the neck in their narrow compartments by a rope or chain, others fastened by each horn, so as to forbid the least lateral movement. And in the trough before them was found an acrid swill, which, in my belief, no living creature could receive into its stomach without engendering disease. I will not sicken your readers by any further details, but only remind them that the milk of these animals and that of another immense stable in Franklin Avenue, which we also visited in a like condition, is daily served to them in their tea and coffee as pure orange country milk, as indicated by their carts which stood in the yard.
Thanks, Barry. So, according to an article in the New York Times, there were 4,000 cows kept in Manhattan, and 2,000 were attached to distilleries in 1857. And the Times estimated that pure country milk accounted for 36 million quarts in 1851, and almost 66 million quarts were swill milk. This so-called swill milk was very thin and of a pale bluish color. In order to disguise its bad qualities, it was filled with starch and sugar, flour, plaster of Paris, chalk, eggs, and other things. And people thought that this adulterated milk, this swill milk, was making people sick. 8,000 infants died, and their deaths were attributed to swill milk in 1857 in New York City. But we know in hindsight that other things were at play too. The churns that the milk was kept in when it was transported weren't washed regularly. The milk wasn't pasteurized yet. It was being carted around in the summertime in the heat, and people weren't washing their hands. In addition to the safety risk, consumers were paying for what they thought was good country milk for something that was of a much lower quality. So in 1862, New York State passed its first milk anti-adulteration law, called an Act to Prevent the Adulteration of Milk and to Prevent the Traffic in Impure and Unwholesome Milk. And part of that law required that milk wagons and the churns be labeled accurately with the source of the milk. And it also imposed a fine that's worth about $700 a day, and it was a misdemeanor if you were caught with adulterated milk. But that law didn't solve the problem because there were problems with a lack of enforcement resources, and the Times ran a series of articles about the milk inspectors being paid off. So eventually New York City banned the swill milk dairies. Now, I started with milk because that's the topic of our presentation tonight. But adulterated food problems in the 1800s weren't limited to milk. In London in 1858, there was a terrible tragedy involving peppermint lozenges. At the time, it was common for candy makers they'd make their candy with sugar and water and flavoring, but sugar was expensive, so they would add things like plaster of Paris and gypsum to the candy. And in this case, Bradford, the candy maker, sent his assistant to the druggist to get some plaster of Paris. And the druggist said, go upstairs to the attic and go to the barrel in the back. And he did so, and he got this white substance, and they made the candy. And 10 children died and 10 adults died, and they realized the reason why was the plaster of Paris was actually arsenic. Coffee was often adulterated with roasted beans, clay, mahogany, shavings. In fact, the first time that a microscope was used to detect food adulteration was used with coffee, and that was 1850. The microscope was invented in 1590. Tea was often adulterated, and this is really scary. Well, it was mostly imported in those days to America, and sometimes the importers would sell us used tea, and in order to conceal the fact that it was used, they would dye it, and they would dye it with lead or Prussian blue, so people were drinking poison with their tea. In addition to food adulteration, there are also related problems with medicine. This is a medicine called balsam of horehound, and it contained opium. And there's no disclosure in this advertisement that it contains opium. And here's one that clearly discloses that this is cocaine tablets for hay fever, but there's no warning that cocaine is addictive. So a chemist at the USDA was really interested in food adulteration, as were a lot of people. There were a lot of books and articles being written on the topic. But he's credited with the first federal food adulteration law. His name was Dr. Harvey Washington Wiley, and he got a grant from the U.S. Department of Agriculture for $5,000. And with this grant, he enlisted these 20 handsome young men to eat poisons that were commonly used in adulterated food products. So they were eating boric acid, they were eating formaldehyde, and the surprising thing is that a lot of people volunteered to be on the poison squad, but the unsurprising thing is that the people who did get chosen got very sick. This was their slogan, none but the brave can eat the fair. So along with Harvey Wiley, Alice Lakey from New Jersey, who was the chair of a women's club, traveled the country lobbying for the Pure Food and Drug Act. And so did George Thorndike Angel. And I wonder if anybody here knows who he is. I knew you would. He was the founder of the Massachusetts Society for the Prevention of Cruelty to Animals. So the three of them were credited for lobbying on behalf of the act. But industry was also in favor of it too, for the most part. This is a quote from Heinz that said adulteration created suspicion of the quality and purity of all other products on the market. But as I said, it was introduced in 1903, and it was languishing for a few years. The whiskey producers were against it, and so were the patent medicine companies. They thought that the government had no business telling what Americans should eat and what we could take for medicine. So something happened, though, in 1906. A writer wrote a novel about some workers who worked in a Chicago stockyard. And would you read a passage from that?
Novel about the Chicago stockyards. There was never the least attention paid to what was cut up for sausage. There would come all the way back from Europe old sausage that had been rejected, that was moldy and white. It would be dosed with borax and glycerin and dumped into hoppers and made over again for home consumption. There would be meat that had tumbled out on the floor in the dirt and sawdust, where the workers had tramped and spit uncounted billions of consumption germs. There would be meat stored in great piles in rooms, and the water from leaky roofs would drip over it, and thousands of rats would race about on it. It was too dark in these storage places to see well, but a man could run his hand over these piles and sweep up handfuls of the dried dung of rats. These rats were nuisances, and the packers would put poison bread out for them. They would die, and then rats, bread, and meat would go into the hoppers together.
Yeah, does anyone recognize what that's, yeah.
The jungle.
The jungle, yeah. So the Doubleday published the full jungle in February 1906. And within 4 months, the Pure Food and Drug Act had passed because meat consumption had dropped to about half in the months following the publication. So the original Pure Food and Drug Act, which no longer exists, was formally an act for preventing the manufacture, sale, or transport of adulterated or misbranded or poisonous or deleterious foods, drugs, medicines, and liquors, and for regulating traffic therein and for other purposes. And it was pretty short. It's only about 2 pages long. And it didn't contain anything at that time like standards of identity. But the USDA realized that having standards of identity, baseline standards, would help them determine and enforce the law against food adulteration. If you think back to that definition of maple syrup, it's very helpful to know that you've got to have at least 66% of the weight being from the maple tree. If it's more than that, if you have more water, and the percentage dips down, then it's easy to tell that it doesn't meet the food standard and it's been adulterated. And at that time, the food standards in 1919 also had standards for goat's milk, ewe's milk, and etc., as they called it in the circular. But the USDA didn't have any statutory authority to issue these food standards. And so the federal courts weren't certain whether they really had authority to be doing this. In Missouri, the district court held that the USDA food standards were not controlling. In Ohio, the district court held that they were controlling. And in Minnesota, the court held that any reasonable standard would be okay, even if it conflicts with the USDA standards in Circular 136. In addition to not having clear statutory authority to issue food standards, the Pure Food and Drug Act didn't cover cosmetics, and they were being increasingly used. And it also didn't cover ads, like this is an ad for soap that claims to wash away fat. So in 1938, FDR signed into he signed into law the Food, Drug, and Cosmetic Act, which is what we have today. And the Food, Drug, and Cosmetic Act expressly authorizes the Secretary of the Food and Drug Administration to issue standards of identity. And it also says that a food is deemed to be misbranded if it purports to be or is represented as a food which a definition and standard of identity has been prescribed by regulation. But there was a problem with these standards of identity. There was a concern that they were limiting innovation. In 1966, 50% of foods in supermarkets were covered by a standard of identity. And I haven't been able to find a statistic about what it is today, but it's a substantially lower fraction. And in 1969, the White House had a conference on food, nutrition, and health. You can see Pat Nixon greeting Girl Scouts who were attending the conference. And members of the conference had some recommendations for guidelines for federal action. They said that the food standards should provide maximum flexibility and incentive for the marketing of new variations and new food to the public. They should provide a wider consumer choice of foods. And the label or labeling of a food should bear whatever information relating to its composition and nutritional properties is important and useful to consumers. So remember, the Food, Drug, and Cosmetic Act was passed in 1938. In 1972, the FDA got around to proposing a new standard of identity for milk and cream. There hadn't been one since the circular in 1919. And the Federal Register notice cited the findings of the White House Conference on Food, Nutrition, and Health. And this is what resulted. It says that milk is the lacteal secretion, practically free from colostrum, obtained from the complete milking of one or more healthy cows. It's similar to the original 1919 food standard. But now it had specifications for solid and fat content. It allows for the addition of vitamins A and D expressly. It allows for other optional ingredients such as fruit, natural and artificial food flavorings. So you can see that that's kind of their idea of innovation, and carriers for vitamins A and D. And it also required specifications for labeling. And the FDA also passed by regulation labeling requirements. And also in 1990, just related to this, Congress passed the Nutritional Labeling Health and Education Act, which changed the information that was available to consumers of food products. You can see a label that's pre-FDA regulation requiring ingredients be listed on labels, and pre the Nutritional Labeling Health and Education Act. All that it says is milk chocolate with vanillin and artificial flavoring. And that's from 2002, and you can see the nutrition facts label. And it's probably hard to see, but they've actually got the sub-ingredients of milk chocolate spelled out in a parenthetical, so you know exactly what's in there. So with that, I'm going to turn it over to Nigel, who will bring you up to date on the current debate about food standards and the labeling of innovative food products.
Thank you, Lori, for that history lesson. That was very interesting. I should give the same disclaimer that Lori just gave, though I've represented the Good Food Institute in court and before the FDA. I'm here speaking for myself. My views don't represent the Good Food Institute or any of my other clients or anything like that. So I'm here to talk about the kind of current debate over naming plant-based alternatives like soy milk, almond milk, soy yogurt, cashew cheese, what have you, using dairy terms. But before I get into that, I actually want to go back in time like Lori did and talk about a little history, because I think it's informative here. Dairy farmers for a long time have been opposed to changes in the American diet that would minimize the share of milk and milk fat in particular in the American diet. It's kind of a theme throughout history going back to the time that Lori was talking about, the 19th century, through today. I'm going to talk about a few examples of that first. I'm going to start in 1860-something in France, where a French scientist, whose name I can't pronounce, was commissioned by Napoleon to come up with an alternative to butter that would be cheaper and could feed the working classes and the soldiers. What he came up with, made from beef fat, beef tallow, is margarine, oleomargarine as it was called back then. That made its way across the Atlantic in about 1870, and here in New York, a New York inventor patented a process for making this margarine out of vegetable oils as well as animal fats. And the dairy farmers did not like this. They went to Albany, they went to the state legislature here, and they banned margarine in the state of New York completely. That got challenged in court and made its way all the way up to the highest court in the state, the New York Court of Appeals, which said, no, you can't just ban a product just because it's new and you don't like it. There has to be a good reason. Of course, that didn't stop the dairy industry from doing the same thing in other states, and eventually it made its way to the US Supreme Court, and they struck those state bans down as an interference with interstate commerce. Just a quick question. How many of the audience here is lawyers, and how many, raise your hand, show of hands, lawyers? Okay, pretty much everyone. All right, so I'll keep on talking about the legal precedents also. So the dairy industry didn't stop with banning margarine. Once that was thrown out by the courts, they took more interesting approaches. In certain states, they required that margarine be colored, strange colors like pink or brown or black. So if you can imagine spreading pink margarine on your toast in the morning, you can kind of see what they were getting at. Now there is a consumer protection angle here, because as Lori told you, things weren't really sold in nice, neatly labeled packages at the time. So if you had margarine, which in its normal natural state is white, if you had that colored yellow and passed off as butter, that could be a serious deception issue. So it's not like there was nothing there, but to have it colored pink was kind of a transparent attempt to make consumers disgusted by the product. That made its way up to the US Supreme Court, and the US Supreme Court said, no, you can't force margarine producers to adulterate their product just to make it look bad. They didn't stop there, though. The next approach was taxing margarine at an extremely high rate of tax, and what they did, this was at the federal level, they imposed a high excise tax on margarine that was colored yellow, and all other margarines, that if they weren't colored yellow, were taxed at a much lower rate. So basically for about 70 years, margarine wasn't sold if it was colored yellow, but the manufacturers did sell margarine that was in its natural state white with yellow food coloring. So I guess if you were a homemaker, you could take this product home, mix the food coloring in with the margarine yourself, wondering all the while why they can't just do this in the factory, and then serve that to your family, and it'll have that nice, pleasant yellow color that butter does. So that was the law until about 1955, when they decided to get rid of those silly taxes. And now another example. Has anyone here, some of you here probably have, heard of filled milk? Do you know what that means, filled milk and filled cheese? So filled milk and filled cheese were products also that were developed in the 19th century, where you take skim milk, which in many instances is kind of a waste product from dairy farms once the valuable milk fat has been skimmed off. Sometimes there's just not much of a market for it. So you take that skim milk and you add vegetable oil to it, and you make cheese out of that. So it's kind of like it is kind of an imitation cheese product. The dairy farmers went to Washington and got a really high tax put on that, and you basically didn't see it for the next 80 years. The tax was eventually repealed in, I think, 1974 or thereabouts, but the product really never took off. Filled milk was a very different story. In this case, this was in the early 20th century. A company developed a product that was skim milk mixed with coconut oil. Dairy farmers didn't really want to take any chances with this product. They went to the federal Congress, convinced them that basically children would die if they could consume this product because of these new substances they had discovered called vitamins. So Congress banned the sale of that product in interstate